Hey there, it's Michael Gottlieb. Wanted to talk to you today about a call that I had with a client the other day. Client had somebody that had applied for a job, seemed an amazing candidate, and then they ran the background search, and it turns out that they were a convicted felon. And client is no longer interested in this candidate. And so they're asking, what do we do now? What do we tell them? And according to the Fair Credit Reporting Act, there's a series of steps that we must comply with if we've used a third-party agency to do the background check. So I wanted to just make sure that you know that there's a whole process that you have to follow if you're going to make a decision about somebody's employment related to a search that you've had a third party do. Any searches you do on your own, totally fine. Any searches, and that does not implicate the Fair Credit Reporting Act, but any search that you do done by a third party to check the background, to check the credit, to check whatever you're checking, that requires and subjects you to the Fair Credit Reporting Act and requires you to comply. So what do you have to do? What does my client need to do in light of the fact that they don't want to hire this person that's a convicted felon? Well, what they need to do first is send in a preliminary adverse action letter. And there's a whole process by which you go through to send that letter. The important parts are that you're going to send the letter, you're going to send a copy of the report that you got that shows in this case, the felony conviction, and there's also a flyer that you have to provide called a summary of your rights under the FCRA. And those things are usually provided by the company, your background search company. So usually my clients are able to have them do a lot of this work for them. Then once we've sent that, the candidate has 5 to 10 business days or so to respond or dispute whatever it is was in the report. Maybe it's happened before where maybe they have a very common name and it's somebody else's criminal record and they're able to establish for you that it wasn't actually them. Well, great, then we can move forward with hiring them. But if it was in fact them, then you may want to move forward with a final adverse action notice, which basically says we're still not going to hire you. But the reason I wanted to talk to you today is because I want to make sure that you do it, because if you don't, the fines are dramatic. You can be penalized severely for failing to comply with the FCRA. You can get fines from the relevant agencies. You can be sued by the individual themselves for all kinds of different things, for violating, but also specifically you can be sued for their wages that they're not now earning because you didn't hire them. So make sure to do it right. If you have any questions, feel free to ask us. Thanks.